So we're here today. The guardian ad litem filed a report and filed it on the 21st of September. I've read over that and I've read all of the subsequent pleadings that were filed by the parties. First off, let me just ask if Ms. Corey, if you have any additional comments other than your written report that you filed.
I did misspeak in one part of the report regarding the domestic violence evaluation. There was one section where he wasn't rated low risk. He was rated with average stress coping abilities. Other than that, this report was primarily about stability, as far as which parent was going to be able to provide a more stable home for Callista. And I can answer to any of the accusations made as well if you wish.
I've read everybody's input, so I'm comfortable having read what people have to say, and I'm sure we'll hear more from the attorneys.
Okay.
So if you want to have some time at the end, I'd be happy to turn some time to you to share any additional thoughts after you've heard from the attorneys.
Thank you.
Okay, Ms. Looney, I just want to double check with you to see if you have any input at this point.
No, Your Honor, I'm here mainly for the order presentation.
Great. All right, thank you. Maybe we should take care of that first. We had a hearing before we get started with the guardian ad litem report review. There was a hearing on the 12th where several rulings were made. And when I looked yesterday, I didn't see any proposed orders that had been filed. Had proposed orders been filed by any of the parties?
They haven't, Your Honor. We prepared proposed orders, and unfortunately, we weren't able to distribute those until yesterday.
Okay. Okay. So those have been distributed yesterday.
They were.
Okay. So then, as far as that presentation date, we can probably talk about that and in conjunction with any follow-up from the guardian ad litem review. So we'll kind of choose a date here at the end. We can review both things. Okay, great. Thank you. All right. So here, let's just hear from Mr. Reed as representing the petitioner. You can go first with your comments related to the guardian ad litem report, and then we'll hear from Ms. Schwantor.
Thank you, Your Honor. Your Honor, the report seems to have several problems. It appears to rely on one.
The judge wastes no time setting the tone for battle.
Ms. Turner staying in a shelter due to lack of funds. Number two, Mr. Day's account of the conditions of the home at the sale. Three, reports of abuse by Ms. Turner from Mr. Day and his references. And fourth, the child's expressed preference to live with her father. As previously expressed in this court, Ms. Turner has struggled financially since the party separation. Mr. Day has profoundly neglected his responsibility to provide support, not just to Ms. Turner, but to his child. This issue could have been cleared up on the closing of the sale of the house by allowing Ms. Turner to access those funds, but in his fiscal comfort, he continues to hold her captive by denying her requests for those funds. Staying in a shelter is currently her only resolution. That can be fixed once she has access to the funds from the sale of the house. But again, she just hasn't been able to do that. The report was clearly one-sided. Ms. Corey interviewed Mr. Day and his friends and family, all who supported him, and trashed Ms. Turner, but either did not interview Ms. Turner's collateral contacts or did not consider their comments. None of her support was expressed in the report. Similarly, she interviewed Ms. Turner's former partners who are allied with Mr. Day as his friends, and they gave her a description of Ms. Turner consistent with his. There was no contact with the child's teachers or other school officials. There was no personal review of the condition of the house, only reliance on Mr. Day and his self-serving comments. The report indicates the child was asked her preference. The RCW 2612-175 says if a child expresses a preference regarding the parenting plan, the guardian ad litem shall report the preference to the court, together with the facts relative to whether any preferences are being expressed voluntarily and the degree of the child's understanding. The GAL did not provide any supporting information at all, simply said she had talked with the child said she wanted to live with her father. And the GAL had been informed that Mr. Day had expressed that he was bribing the child to make these comments, but instead of relying on that, she only relied on the comments of a 6-year-old. The GAL does not appear to give any weight to Mr. Day's acknowledged narcissistic violence toward Ms. Turner. He's shown great hubris in breaking into her house during this proceeding, and none of that was considered. There was, as Ms. Corey discussed earlier today, there was reliance on the DV evaluation, and while that evaluation was mostly favorable towards Mr. Day, there was still a recommendation that he needs to take. He needs to have counseling. He needs to take a course. He needs to have treatment to address these issues, and that wasn't expressed there. If the GAL's recommendation is adopted, this case becomes a relocation. These parties live.
Buckle up, guys. Tempers flare as objections fly across the room.
Hundreds of miles apart. None of the factors related to such a dramatic relocation have been considered here, since the only factors that advantage the child in such a relocation relate to the father's already existing financial advantage, which appears to be what Ms. Corey is relying on here, is simply stability, meaning Mr. Day has a better financial advantage than Ms. Corey. Or than Ms. Turner. The court really needs to consider that he has already been found neglectful of those responsibilities, and that putting the child with the father under these circumstances would take her away from friends and family that she already has in this area, send her to a part of the state where she has no support, no other friends or family other than her father, who has already shown his narcissistic attitude, and it could be putting the child in considerable danger. Thank you, Your Honor.
Thank you, Mr. Reed. Ms. Schwantor? Looks like the mute button's depressed.
Good morning, Your Honor and counsel. I respectfully disagree with counsel's assertion. Your Honor, just a few issues. In regard to the payments, I wanted the court to be aware that my client has made all spousal support payments with the exception of the October payment, which he expects to make by the end of the week. He is having the child support garnished from his paycheck. He has paid the court's order civil fine, as well as the $2,000 in attorney's fees. So Mr. Day is nearly up to date with his financial obligations as ordered by the court. I want to remind the court that Mr. Day, as I understand it, voluntarily engaged in a domestic violence evaluation, and I will tell the court that he is willing to engage in whatever program that the court orders. However, on reviewing the evaluation, I would ask the court not order Mr. Day to engage in a treatment program. I want to address some of the issues that are raised regarding the guardian ad litem report. First of all, my request to the court today is that the court adopt the recommendations of the guardian ad litem report. I do not believe there is any demonstrated bias. I believe that there was a thorough investigation. We see on page 2 that she engaged in a number of interviews, a number of collaterals and references for both parties. She reviewed police reports, DCYF records. She even reviewed a news article, watch reports. She reviewed the domestic violence evaluation. I believe that this was an extensive and complete report and does not have any bias as asserted by the petitioner's attorney. I believe that the guardian ad litem appropriately considered the criteria that's set forth in 2609-197. The court is to consider the relative strength, nature, and stability of the child's relationship with each parent, and which parenting arrangements will cause the least disruption in the child's emotional stability while the action is pending. The court's then instructed to look at the criteria for establishing a permanent parenting plan. And again, the factors that stand out here is stability. I believe that what was learned through this guardian ad litem report was that, the lack of stability in the petitioner's life did not begin or end with Mr. Day. This is a pattern. She has had significant instability in her living situation, in her employment situation, and this has impacted the children. So for example, her child Taylor wasn't enrolled in school until the age of 10. Callista didn't attend kindergarten. There are significant concerns raised by my client and as well as in this report regarding substance abuse. Now, it was helpful that petitioner did provide a hair follicle, but I'll tell the court that I don't know what that means. Does that mean that someone hasn't used marijuana yesterday or 2 months ago? So it's very difficult to evaluate and make any sort of conclusion based on that one test alone. And again, I would just ask the court to follow the recommendations of the GEL and have the petitioner engage in an evaluation, which would provide some sort of history and report from the mother and fully inform the court regarding substance abuse issues. The father provided the court with through the GAL, the GAL provided the court with information regarding what would where the child would go to school. If with the father, he would have the child at the local elementary school. She would be in aftercare at the Boys and Girls Club. He is fully prepared to take on the responsibility. I would also note that 2609-187 asked the court to look at not just past performance of parenting functions, but future as well. And I think again that the GAL is correct, and that what should happen now for the child's stability is that the child should be placed primarily in the care of the father. I'm happy to answer any questions the court may have. Thank you. Excuse me. Sorry, I have one more comment.
Sure.
It's my position that the Relocation Act simply does not apply. Those factors are very specific to a parent relocation, a primary presidential parent relocation, not an initial custody determination. So the factors that apply here are set forth in 2609-197 and 187. So I do not believe that the Relocation Act applies to this this proceeding.
Okay, so give me the reference again for the relocation 26.
So the factors that apply are those set forth in 2609-197, which is issuance of a temporary parenting plan, which references the 2609-187 factors. In a relocation, it's my position, and I believe that's correct, is that that law is implicated and the court is required to engage in a relocation analysis when a primary residential parent is proposing a move with a child. So under this circumstance, the court is making, I would argue, a temporary parenting plan.
So we have a temporary parenting plan, correct? That was issued on May
Correct.
2nd. So there's it there.
Correct.
That's there. And
Right.
so your position or argument is that the relocation factors don't apply because.
Correct. We follow the residential parent, Your Honor. And in this case, we're making a change in custody. So I believe that that statute is specific to a primary residential parent moving. And I believe that that would be supported with the case law, even when we look at, if we have a 50-50 parenting plan, we don't look at relocation factors, we look at modification factors instead of relocation factors. I would say to the court that there are some similarities in the factors. I would not disagree, for example, that the court in making a temporary plan should look at, the child's relationships and child's involvement with surroundings or school or other activities. That's certainly something that the court considers, which is similar to, the criteria that's set forth in a relocation action. But again, they're different. So
Okay, I
Did you have-
appreciate that explanation. I was just taking a moment to go over the
All right, guys, a key piece of evidence flips the tension in an instant.
2609 statute related to relocation.
Okay. I guess I should point out that in the attorney for the mother mentions that, you know, the child had expressed a preference to be with a father, but did so without any reason. But when you look at it, the child says, well, my mom yells at me all the time. You know, my dad listens to me, he talks to me. So despite being a child of 6, she certainly was able to articulate some reason for her preference. And my client absolutely denies that there was any sort of coaching or any sort of gifts or anything like that to convince the child to say one way or the other.
Okay, all right, thank you. Mr. Reed, any follow-up?
Ms. Schwanter has, her comments on the relocation are completely valid. Of course, this is not completely a relocation case. We don't have a primary parent moving. However, the purpose of having the factors for relocation still relate in this case. We're talking about the possibility of moving a child from one part of the state to a completely different part of the state, and it would be it would be irresponsible for us to not consider at least the same kinds of factors in moving that child. If that relates back to the stability and environment of the child, you know, that's fine. But again, as I point out, what appears to be the real problem in this case is that father is better able to financially pay for the things that he needs to pay for, and mother has relied on him to help her, to support her, and he has refused to do so, and that appears to be why mom has a sense of instability.
Thank you. Before I hear from Ms. Corey, I just want to again focus on that the procedural question as far as a relocation, because kind of, you know, if the court accepts the recommendation of the guardian ad litem, it would amount to a relocation. And so while Ms. Corey's report focuses on the best interest of the child and her duties as a guardian ad litem, and while she does cover and address some of the relocation factors, that's not the focus of the report. The focus of the report is more broad and maybe not as laser focused as the relocation factors would be. And so I guess my question then to the parties is, if we have a temporary parenting plan in place, if a guardian ad litem makes a recommendation that there should be a change, which includes relocation, should the court necessarily be focused on those relocation factors, and should the parties, as 2609-510 says, have an adequate opportunity to prepare and be heard on that issue? So that's my question. Ms. Schwanter, you kind of addressed that, and anything else you want to share on that? And then Mr. Reed, I'll hear any comment you might have.
No, Your Honor, it continues to be my position that the Relocation Act does not apply to this matter. And I would point the court to the factors that are set forth in 2609-187. And I would note that some of the factors are similar. I believe that all the 2609-187 factors are addressed in the report of the guardian ad litem. The court notes appropriately that the factors are different. And I would point out that, you know, when you look at a relocation, you're looking at what are the reasons for the relocation, what's the financial benefit to the parties. That clearly the statute envisions a different factual circumstance than the court has before you today. And again, my position is that that issue of stability is the main issue here, as the GAL pointed out, and stability is best achieved by placement with the father. And again, the mother is still in an unstable position. She's currently at a shelter, so she will certainly move again. And will she move to another school district? Maybe, we don't know. And I think that's part of the problem here.
Thank you. Mr. Reed.
Well, Your Honor, the RCW 2609-520 on basis for relocation, it gives us the reason for addressing these factors as that there is one party proposing to relocate with the child. And the court needs to be looking at the reasons for that relocation. It doesn't actually say that it is intended for a final parenting plan that is now being modified. It is simply one parent is looking to relocate with the child. And so I think that the factors, they still have weight here. Ms. Schwanderson indicates that, well, they're mostly the same. I don't think they're mostly the same. I think there are some similarities between the two. But one very important factor that the relocation statute brings up is the disruption, not just with the child, but with the relationship between the child and the parents. This child has always lived with her mother, and there would be a severe disruption. Yes, there have been moves because the party sold their house. That was going to happen. The fact that there's going to need to be another move is only related to the fact that dad has not been willing to help mom to financially support that move. One of the factors in 2609-520 is whether there was a prior agreement of the parties that exists in 187 as well. And the agreement of the parties up to this point has been that the child would live with her mother. Considering all the factors that on both statutes, I think the court has to look at whether this is going to be disruptive to this child. If she is forced to move back with her father to a location where she has never lived and where she is simply unfamiliar, and that there is just nobody there to support her and help to take care of her other than her father, who, as I've indicated before, has already expressed severe control issues.
Thank you, Mr. Reed. Ms. Corey? Looks like the mute button's depressed.
It's without fail. I apologize. When I say stability in this report, I'm not just referring to financial stability. I'm referring to emotional stability for this child. A lot of concern after I spoke with the parents of Ms. Turner's other children and learned that twice she had left with no notice to those parents. She still has no
Buckle up, guys. One side slips under pressure with a crucial admission.
No parenting plan in place with the son, and the custody for the children, for the older daughters, was due to the lack of her stability at the time. So it's not just a financial thing. It's stability across the board.
All right, thank you, Ms. Corey.
As well, I did also have some concerns with the substance abuse issue, which I actually didn't learn of until late in the investigation. In the intake that Ms. Turner filled out for me and signed as true, she states that her only I ask, have you ever used drugs? And she replies, yes. If yes, what drugs have you used? And she replies, CBD, and that she only uses them occasionally. If that's true, I think that would be great, but I have no evidence of that at this point. And she said one thing, the witnesses said another.
All right, thank you.
Mhm.
All right, so with regard to the guardian ad litem report, I think guardian ad litem reports are somewhat difficult. The guardian ad litem is put in this position where they need to contact and hear from both sides. They hear from both sides, and the designated people that the parties have indicated, this is my reference, please talk to them. And I think most guardian ad litems try to be even-handed in the amount of time and the number of people that they interview or talk to on both sides. So I can see where Ms. where Ms. Turner is coming from, where she might feel that, based on the information that those parties have shared, that there's not follow-up investigation into things that are learned during those interviews. My understanding with guardian ad litem reports is that they speak with the people and they gain information from them and they report that information to the court. It's while there may be times where it may be important to do some follow-up investigation, that's not always the case and not always required. A lot of the times it's just taking that information, receiving it and packaging it and presenting it to the court in a recommendation and the factual basis for their statements. And so in a perfect world, we would have all kinds of guardian ad litems and all kinds of monies to pay for them and all types of hours to pay for them. That's not the world we live in, unfortunately, and because these are very important issues and monies are just not simply allocated for them at this point. So I want to just share that viewpoint as far as my viewpoint of the guardian ad litem reports. The guardian ad litem points out the main concern, which has been emphasized by both Ms. Schwanter and Ms. Corey, that the stability is the main thing that leads to their recommendation for a change. Mr. Reed makes a very good point that, lack of income or a lack of finances should not be the controlling factor of a parent-child relationship and a determination of custody. I think it's important to note that it sounds like Ms. Turner has made a decided decision to spend as much time with her children, doing things with her children as possible, and putting on the back burner creating income. I think that's borne out through her activities with volunteering at the school and with her statements to Ms. Corey related to when it's convenient for her to work, she will work. So while some of the financial stability could be increased by more work, there's been a decision by Ms. Turner not to do that because she places emphasis or preference or importance on other things. So my big question in addressing this issue is that, the guardian ad litem report makes a recommendation that's a big change. It's a big change, the recommendation. It's moving a 7-year-old girl from the home, the community that she's known for most of her life, to a new community. And there's lots of good reasons for that. Ms. Corey, and that's, gives voice to many of those reasons. So that's where my concern comes from, is that where here we don't have one party petitioning the court for a relocation. We don't have that. So we don't have that rebuttable presumption that says if you're a primary parent, you get kind of the nod, you're in the lead, and you're likely going to be allowed to relocate. Here we have a non-custodial parent who is relying upon a review of information from the guardian ad litem and kind of tagging on to that and saying, yeah, we like that, let's do that. Let's make the move now. And so when I look at that, what the decision to make on this, when I think about the relocation factors, although they are more or less addressed or touched upon or alluded to in the guardian ad litem report, there's not that kind of a laser focus where you go down and you say, okay, these are the 11. Okay, I'm going to be talking about factor number 3, which is the disruption of contact between the child and the person seeking the relocation, and whether that's good for the child or detrimental for the child. There's not as much maybe information or thought or ink given to that. On the other hand, I also think that the guardian ad litem review, it has been presented. How much more information do we need than what the parties have shared and what the guardian ad litem has shared? And also take into account finances of bringing another motion to court and how that impacts the parties. So I'm sensitive to that also. The information that we have is that there's stability issues in the mother's home. That's the information that's coming from Ms. Corey and from Ms. Schwanter and her client. What I'm not hearing is that there's any imminent risk to Callista, to the child. I'm not hearing that. I'm not hearing that there's imminent risk. While there may be greater stability.
All right, guys, the judge finally snaps and lays down a strict warning.
With the father, I'm not hearing that there's in the current living arrangements, while they may not be stable and there's inherent instability, just because kind of living on the edge without funds and moving and the like, and other issues that were raised in the report. And that she may be getting an apartment soon if she gets some money through child support. So because of those things, I don't think I'm going to make a change today. I'm not going to make a change as far as the parenting plan, because I would, because it is a significant issue, I would feel more comfortable if we had the specific information related to the 11 factors. If there's a motion to change custody, which that very well may be Mr. Day's next step, is to ask for that and move the court for that, then he could enunciate clearly his reasons why he feels that that's appropriate. And Ms. Turner can enunciate her reasons why she feels that's not appropriate. The guardian ad litem could certainly chime in on that more directly than she already has. So I'm going to hold off on that specific issue. However, I'm going to provide some interim rulings related to an SUD evaluation or substance use disorder evaluation for both mother and father. I think both need to have that evaluation completed. And if there's any recommended treatment, get started on it. I will adopt the recommendation of our family wizard. That should be started soon. Each party will have to sign up and you pay your fair share. I think it's half or whatever it is. So that, yeah, each party will pay their portion. And I also think that it'd be appropriate, and I see no downside to this, that both mother and father complete some parenting classes. So for the father, Love and Logic, he should complete that, sign up, take that. And for mother, she should take the Parents in Between class. I think those recommendations are well taken and can be implemented now, and it'll provide benefit to the child. But as far as the bigger, more salient, weighty issue, as far as moving the child from this county to Richland, Washington, I think we need to have a more focused discussion on some of those factors that are related to the relocation. So if the parties want to bring that in the future, we could certainly address it, but today I'm going to hold off. So that's kind of where we're at. So there's kind of these interim, maybe smaller pieces that were ordered today. I guess I could, since no party is really a moving party, then I could probably draft that and then just submit that and send a copy to the parties. So I'll do that. So I'm just going to give myself a note here. Okay, so I'll ask the parties if you have any questions or points of clarification at this point.
Your Honor, do you have a specific requirement as to the type of SUD evaluation?
Tell me more. Tell me what that.
For example, is it hair follicle? Is it nails? A 12 panel?
So my understanding with a substance use disorder or a substance abuse evaluation, that's principally done through a conversation with the individual and any collateral input that could come from Ms. Corey or the other party. And my understanding and experience has been that they don't necessarily resort to a UA or to hair follicle. If that's part of their normal process, obviously that would be required. But my understanding is that's not common. I'm not familiar with that.
Okay, thank you.
Sure. Ms. Corey, did you have a point to make?
No, just to ask that there be collateral input for both.
Yeah, that's appropriate. I'll include that in the order. Ms. Schwanter.
And as to the domestic violence treatment program for Mr. Day?
My understanding is that he's engaged in that, or is he not engaged?
He's completed the evaluation, Your Honor.
Okay. And so there's been no start to that?
Not yet, Your Honor.
Not yet. Okay. Again, I think that the similar to my reasoning with the class, the Love and Logic, the Parents in Between classes, I don't see any downside to the child. I see upside to the child for father engaging in the recommended treatment. It's a 6-month period of treatment. It starts heavy and it gets thinner, or as far as amount of time in class as the class goes on. So I think that that's appropriate, and I'll require that. Okay, so I will get that order out to the parties today. And that'll be filed, and any additional items before we break today.
We still need a new date for the existing temporary order.
So you said you need a new date for the existing temporary
Yeah,
order?
for entry of the, yeah, you had put that off till the end.
Yes, thank you for the September 12th date that we had the hearing. Thank you for reminding me of that. So let's take a look at the calendar. Mr. Reed, since it sounds like you got those sent out, and Ms. Schwantord, we will have those, I would assume, shortly. 17th of October, Tuesday. How does that look for the parties?
No objection.
That looks good. Thank you.
Orange for the state, Your Honor.
Great, thank you, Ms. Looney. All right, so we will see everybody on the 17th of October, 9 a.m. for presentation.
Thank you, Your Honor.
Great, thank you both.
Thank you, Your Honor.
Buckle up, guys. The court delivers its final order closing the case.